Welcome to Legal Studies, and today we're going to be learning about the express protection of rights in our Constitution. So where are we? Well, here we are. We're learning about yet another one of our checks on Parliament in lawmaking. So each of these things that we're learning about are basically like contingency plans. If Parliament decides to go rogue, if Parliament decides to start doing some crazy stuff that we don't really want them to do, what are the contingency plans we have in place to try and limit Parliament a little bit and protect us? And the express protection of rights is one of the more clear protections that we have in our Constitution. And essentially, what it is we're talking about the 5 rights that are written down in our Constitution and expressly or explicitly protected. Right? The Commonwealth Government is prevented from making laws that violate any of these rights. And what are they? There's 5 of them: freedom of religion, freedom of interstate trade and commerce and movement, right to receive just terms when the Commonwealth acquires your property. So the Commonwealth can take your stuff if they want, but they have to pay you for it. Right to trial by jury for indictable Commonwealth offences, and the right not to be discriminated against on the basis of the state that you live in. So there's only 5 rights, so it's kind of limited, and some of them are kind of dodgy, as you can see. I mean, this right here, the right to let the Commonwealth take your stuff, but at least they have to pay you for it, kind of weak sauce. But they're what we got, so let's dive into them. So the first of these rights, freedom of religion, prevents the Commonwealth from creating their own religion, from requiring anyone to perform any particular religious observance. They can't prohibit you from exercising your religion, and they can't require you to be a particular religion to have a job with the Commonwealth. So all sorts of restrictions on what the Commonwealth Parliament is allowed to do. They're not allowed essentially to prohibit the free exercise of religion. So in a way, that acts as a strong check on Parliament in the sense that they're not allowed to make any law that would do that. On the other hand, there are some limits on the ability of these rights to protect us. So, for example, it doesn't prevent the Commonwealth from assisting religions. For example, their practice of funding Catholic schools. All right, that's not prohibited by Section 116. And further, and this is going to be a limitation that a lot of these rights have, it does prevent the Commonwealth government from making any laws in this area, but it doesn't actually restrict state governments. Right? It only mentions the Commonwealth government. So potentially, the states could make laws that regulate religion in some of these ways. Our second right is Section 92. Trade within the Commonwealth should be absolutely free. And so what this refers to is freedom of interstate trade and commerce and also movement. And again, this acts as a check on Parliament because they're not able to make a law that prevents this. On the other hand, there are some limitations on this particular right. So the court has ruled that some restrictions on this right are acceptable, so long as the main purpose of the law is not to discriminate against interstate trade. So, for example, just recently in 2021, Clive Palmer challenged Western Australia's COVID border closure laws. And he said they violated Section 92 because they were preventing him from moving across state lines. They were preventing him from freely trading across state lines, which they did, obviously. But the court held that the laws were still valid because their major purpose was not to try and prevent interstate trade and commerce. Their major purpose was to try and protect public health. And so some limitations on that right were acceptable. Our third right is this acquisition of property on just terms. So basically, the Commonwealth can take your stuff, but they've got to pay you for it. Look, a fairly limited right, even on the face of it, they can take your stuff. So there's a limited protection there that they can take your stuff if they want. It's just that they have to pay you for it. Again, just like many of the other rights, this protects you from Commonwealth government. Right? They're prevented from taking your stuff for free, but it doesn't technically limit the state governments. You've got the right to trial by jury, according to Section 80 of our Constitution. But there's some limitations on this one as well. It specifies that you have the right to a trial by jury for indictable offences, which tells us if it's a summary offence, you don't necessarily have a right to a trial by jury. And it also tells us that this right applies to Commonwealth offences, which again means that it doesn't apply to the states. And that's a big problem because the vast majority of criminal law is actually state law. Murder, manslaughter, theft, robbery, assault, all of the big crimes that you would think of are actually crimes under state law. And so this doesn't guarantee you a trial by jury for those crimes. It only guarantees you a trial by jury for Commonwealth crimes, which are much more rare. They're things like fraud or people smuggling, human trafficking. These are Commonwealth level offences. So again, this right is limited in its ability to protect you in a number of ways. Finally, we've got the express right not to be discriminated against, only though on the basis of your state of residence. This is not a broad protection. This is not a broad anti-discrimination protection. It's only about which state you live in. So an example of that happening, there was a case R and Luby in which it was held that states couldn't make a law refusing to give bail to someone just because they came from a different state. So a Victorian law couldn't deny bail to a Queenslander. Some limitations on this particular right. The court has held that the states can still make laws for the purpose of upholding their state autonomy. So, for example, they could make a law allowing Victorian citizens, only Victorian citizens, to vote in a Victorian state election, even though that would be a minor discrimination based on someone's state of residence. That's still, the court said, permissible. And now, diving into what we really need to know about this topic is some strengths and weaknesses. To what extent do these express rights really strongly act as a check on Parliament, and to what extent are they limited in their ability to prevent Parliament from doing what it wants? So, a couple of examples for us. Really clearly, the main aim of express rights is that Parliament is unable to make laws that directly violate any of these rights. On the other hand, a weakness is that the High Court has allowed many of these rights to be limited by Parliament in a lot of different ways. And usually limitations are acceptable so long as the law is primarily trying to achieve some other really important purpose. On the other hand, if an express right is violated, anyone who's affected by that can bring the challenge to the courts and the law can be declared invalid. So it can act as a really strong check on Parliament and invalidate a particular law that they've made. But thinking again, there's only a limited amount of these rights. There's only 5 of them, and the scope of them is quite narrow. That they don't actually protect a huge, broad range of human behaviour. So it's not exactly a big list of human rights. All right, and that's it for our express rights. See you next time.